this is the morning we would be beginning landlord-tenant matters here in a bit, but we've got an unscheduled matter. Mr. Justin Michael Aiken is here. File number 222036 alleges no insurance under the insurance code. File 222037 ST alleges driving suspended first offense and improper plate. Those are alleged to have occurred on October 18th of last year. Also, the case is file 2240 SM, alleges no insurance and driving suspended on January 1st of 2023. Mr. Aiken is here. This matter was set for jury trial on Wednesday, May 24th. Deborah Davis is here with us from the prosecuting attorney's office. She had been managing these cases, but she was obligated to try another case in the circuit court on Wednesday, very important case. And Casey Johnson was assigned then to handle this case, and he was here Wednesday, ready to proceed. We had prepared the jury instructions. We had 30 jurors here, and we were prepared to go to jury trial on the October 18th case. In your case, you had steadfastly maintained your lack of responsibility. I won't say innocence, but and expressly indicated you did not want to have an attorney to represent you, and you also steadfastly remained in your request for a jury trial. And we were here. We had 30 jurors who all took the day off, and we were prepared, and you didn't show up. And so I issued a bench warrant for your arrest. And I said on the live stream that if anybody knows Mr. Aiken, have him come turn himself in. And that was Wednesday. And here it is Friday morning, and here you are. Mr. Aiken, what's your position here?
Well, Your Honor, I'd like to apologize to you and everybody that was here for the trial. And I got scared that day, and I apologize to everybody for not being here. And if we could work, some kind of financial plan, something of that sort, or whatever you feel necessary needs to be done, I'll get done. I'll take responsibility.
Mr. Aiken, have you paid your ticket in Coldwater?
I'm actually been trying to work on that.
Okay, so once that's done, you'll be able to get your license from the Secretary of State again?
Yes.
Okay.
And I plan on getting insurance as well on my vehicle.
Very good.
Well, we still have these two cases, which were set for jury trial. And what do you wish to do with those? You wish me to reset them? Or is there some?
Before you make that decision, the offer of allowing another to violate the motor vehicle code in each of those, which is the offense that doesn't carry any points on your license, so it wouldn't prevent you from getting your license once you pay off your Coldwater ticket and probably a reinstatement fee to the Secretary of State. If you pled to account in each of the files, we would dismiss the remainder.
All right, that was the original offer, and she bent over backwards to make it. So let me repeat what it is. You're charged with two separate incidents, one in October of 22 and one in January of 23. Driving suspended and having no insurance. No insurance is punishable by up to a year in jail. It carries a minimum fine of $200, a maximum fine of $500. It requires you to be fingerprinted, and it doesn't have a restriction. The driving suspended charge requires that your license be suspended. It carries 2 points, fine of up to $500 and up to 93 days in jail. The prosecutor is agreeing to dismiss all of that, plus the plate violation, for 2 pleas to allowing another to violate the motor vehicle code. Allowing another to violate the motor vehicle code is sort of a legal fiction. The other that it is allowing to violate the code is yourself. But it carries no points. It doesn't get abstracted to your driver's license and won't affect your ability to keep or maintain your license. Ms. Davis had made that offer at least twice before and you declined it. Are you willing to accept that at this point?
I'm willing to accept that, Your Honor.
All right, did anybody promise you anything to get you to plead to this?
No.
Diana, you need Debbie?
I just need a signature. Thank you, Judge.
Sure.
And let me out. I'm sorry.
You can keep that.
Am I back?
No, actually, no, I need it back. I just thought you might need a pen.
I don't typically work paperless, but that's an amended information or amended.
All right, Mr. Aiken, let's talk about that. Other than what Deborah said and what I just explained to you, did anybody promise you anything to get you to plead to this?
No. It was all me just wanting to get this taken care of and resolved.
All right, anybody threaten you?
No, sir.
Do you understand that if you do plead to these charges, you'll be giving up your right to have a trial in front of a judge or jury?
Yes, I
If you had a trial, you would have the right to be represented by an attorney. All you gotta do is ask me, but you've been adamant throughout that you did not want to have an attorney to represent you. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so that you could be questioned under oath. You would have the right to take the witness stand yourself and testify, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent if and until the state was able to prove your guilt beyond a reasonable doubt. Do you understand?
Yes, sir.
2230236. All right, were you driving a car in Constantine on October 18th of 2022?
I was driving.
Traveling. Well, did you not have insurance on the vehicle at that time?
I did not. I just purchased that vehicle within a week during that time.
It was a truck.
Yeah, it was a truck.
All right. I'm going to order a $75 crime victims' rights fee, $50 state minimum fee, $125. I'm going to give you until July 1st. All right, that takes care of the first case. In the second case. Oops. That's 2, 3. 40. An order 10 days jail, credit 0, leaving 10 days to serve. Same thing, $125, due by July 1st of 23. I also find that you're in contempt of court for failing to appear for your jury trial on Wednesday. You have some misinformed, misguided notion that the laws of the state of Michigan don't apply to you. People refer to this as sovereign citizen, but that isn't what it is. There's no sovereign in it. I call it willingly misinformed defendants. There's no sovereign about it. And you wasted a whole bunch of our time, the prosecutor's time, filed a bunch of documents that didn't mean anything. You were always respectful, but she made this very generous plea offer several times, but you wanted to represent yourself. You wanted to have a jury trial. The irony of this is that you demanded your rights as a citizen in the state of Michigan to be presumed to be innocent, to have an attorney appointed, and to have a jury of your peers. If you got a jury summons, you wouldn't have shown up. You would have said, I'm a sovereign and you can't dictate what I have to do as a citizen of the state of Michigan. But you're okay if you drag in 30 other people who took the day off work, who were nervous the night before. They came in here and sat around here for 45 minutes waiting for you to show up. And you wouldn't have shown up if you had been a juror. It cost the county $565 in jury fees, and it cost the jurors probably thousands of dollars to come in here for your foolish request. So the contempt was committed in my presence. I'm going to do it in the other case, 2322036. You had been respectful, but that's disrespectful to me, to the prosecutor, and to all those private citizens that came in here because of your whimsical, and I don't even know if they were sincere beliefs. Whoever sold you on this foolishness is cynical. They don't even believe it. I don't know whether you believe it or you're just like messing with the system. But when you involve 30 or 35 of your common citizens who get dragged into this, it's no longer polite or respectful. And you could have had a trial. They would have been here. It would have taken Mr. Johnson about a half an hour to put in the proofs. I also understand, Deborah, he may have 4 or 5 warrants out of Elkhart County, Indiana, and a non-support warrant. So I believe he's also wanted in Indiana. And we'll explore that. For the contempt, I order 30 days, credit 0, concurrent with the 10 days I gave you on the other case. And the cost of the juror to the county
It appears there's 5 separate warrants out of Elkhart for same charge each time: invasion of privacy, violating protective order.
And that's protection orders expired as of January of this.
I don't know, but there's
I mean, they're
apparently
all
warrants
from
for your arrest.
2022, they've been pending. I didn't realize that those were pending when we were doing all this other stuff. I can contact Elkhart County.
Yes. Now, darn it. It was Wednesday. She sent me that. cost was $524.05. So you'll $525 restitution for the cost of the jury. You got a sweet deal from Miss Davis. My advice to you is you get a driver's license like everybody else, like all those jurors that came in here to hear your case. And you stop driving. Now, did somebody bring you here today?
Yeah.
You got 10 days on the driving charge. You weren't traveling, you were driving. You got 30 days for poking me in the eye with a sharp stick by not showing up for a jury. And you've got pending warrants from the state of Indiana and possibly others from Michigan. You're going to be in jail for a while, so I'm going to change that due date to August 1st, not July 1st. On both of those. All right, you can go to the court officer.
Thank you.
You could have made things a whole lot easier. You can have those envelopes, Frank. Thank you, Deborah.
Thank you, Your Honor.
Please subscribe to help the channel.
Okay, here today for a pretrial?
Yes, sir. Judge, I've been trying to get this sworn tape statement from Amanda Weber. That Mr. Sullivan sent me 2 discoveries, but there's no sworn tape statement. He didn't send it. I sent you another motion to compel, and I'm sorry I didn't comply by the rule because I forgot to sign the certificate of service. But I've got another one ready now. I need the statement.
Your Honor, if I could address that issue. So Mr. Nix provided several exhibits to his motion to compel. There's a misunderstanding of what the court's ruling was based on the motion to suppress. In the ruling, there is reference to Ms. Weber's sworn statement. Nowhere does it say anywhere that this statement was recorded. I have reached out to Panama City Police Department to check, and I'm going to read the response that I got. It's from the officer, Raymond McNeil. Says, I thought the statement with Ms. Weber was collected on Officer Hutchinson's body-worn camera due to my body-worn camera being not the one time to stop. After reviewing the body-worn camera with Officer Hutchinson, I confirmed that he terminated the body-worn camera moments before him and I had spoken with Ms. Weber. Therefore, the statement was not recorded. It was not recorded on a handheld recorder. And he did confirm that all future statements would be recorded with handheld recorders. That being said, the statement that has been testified to and talked about was a sworn statement, but nowhere has anybody ever claimed that it was a recorded statement. There is no recording of this statement.
All right.
Judge, I'm Clark, sorry, it states right here on the affidavit. Postman in the morning, Weber did provide a sworn tape statement to the investigators.
And that's my understanding, judges. He believed that it was captured by that body camera, but
Let me just get, when they say they don't have it,
Yes, sir.
that's what I'm stuck with.
Yes, sir.
So I don't know, there's nothing else I can do. Yeah, I mean, they're supposed to, when the demand for discovery is filed,
Yes,
they
sir.
have to provide everything there. They
Yes,
say
sir.
they don't have it, so they don't have it. There's nothing else I can do.
But that's what they got the search warrant all for, sir. Mr. Doodle warrant, the sworn tape statement. That's all they had. There was no sales. She had nothing. It's just all up on this sworn tape statement.
as far as that goes, I mean, whether the statement was given and whether it was recorded or not doesn't change the probable cause for the warrant.
I know.
There were some other issues that Mr. Nix brought up in his motion to compel. I think he had requested the body camera footage.
Yes, sir. When I first got, when they first pulled me over, Sergeant Shaw, which is Captain Shaw, and Corporal Sigler.
And the issue with that is there are body cameras available. They were provided to Ms. McCarthy when
Yes,
she was
sir.
on the case.
Yes,
The
sir.
issue that I have is I can't just give Mr. Mr. Nix a disc with him being in custody. Those body cameras footage does exist and it was provided to defense counsel previously, but with him being in custody, it becomes a little bit difficult for me to provide him that footage.
Ms. McCarthy, did you provide all your discovery to him?
Yes, sir. We can't give him the disc either.
Yes, sir.
He had seen the body cam.
But Your Honor, the first part of where they pulled me over, they did not overturn that body cam. And this is very crucial to my case. They never, before they first pulled me over.
You think I know what you're talking about?
Well,
I mean,
when the body cam starts, Your Honor, I'm already in handcuffs. I need the part where they first got me before I got put in handcuffs.
All I can say, Judge, is all the body cams that are in this case have been turned over. I can't control when the officers turn their body cams on and off, things of that nature. Everything that was recorded has been turned over.
and you've had a chance to, what Ms. McCarthy had, you've had a chance to look at that?
Yes, sir, most of them. Yes, sir.
Okay.
But also, Your Honor, I got another issue. I mean, I don't mean to take up all your time, but I've got another
You're
issue.
not gonna take up all my time. I'm gonna give you just a little bit.
Yes, sir. In the discovery that Mr. Sullivan just sent me, there are two affidavits in there. It's not filed. But by the rule, by this rule, by this rule right here, rule 3.115, the duties of a state attorney criminal intake. The state attorney shall provide the personal or procedure for criminal intake into the judicial system. All sworn complaints charging the commission of a criminal offense shall be filed in the office of the clerk of the circuit court and delivered to the state attorney for further proceedings. In both discoveries, Your Honor, that affidavit is not filed in either discovery.
What you want me to do?
I need them to throw that. They're not filed. I've got the motions here for you.
Mr. Sullivan, any response?
Your Honor, there was a, let me double check this. This was already essentially litigated.
No, sir.
Ms. McCarthy filed a motion to dismiss on August 21st, 2023, dealing with the affidavits.
That was continued, Your Honor. And it never was brought back up. There's only one affidavit filed, Your Honor, and it's got it at the right top corner. It's 22-3101.
This is not my motion day, so if you want to file your motions.
Yes, sir.
Mr. Sullivan has a copy. We'll set whatever's left.
Yes, sir.
January, what is that, the 19th at 9?
Yes, sir. I got your,
Your Honor, I
here's your.
believe Mr. Nix is set for the February trial day. I'd like to leave him set for that date as well.
Yes, sir. But also, Your Honor, deposition has never been taken in this case.
Have you filed your notice to set, have you tried to set depositions?
No, sir, I haven't. But I'm asking now, I need to set them.
You got to set them. I'm not going to set them.
Okay.
You're representing yourself.
Yes, sir.
You're going to have a very difficult time setting up depositions. And you're going to have a very difficult time taking depositions representing yourself.
Yes,
You're going to be you're at a disadvantage.
yes, sir. I
Once
understand that.
again, you have a right to have an attorney appointed to represent you. Mr.
Yeah.
McCarthy, that'll leave you back up counsel.
Your Honor, we've done depositions in this case. I've got depositions of Christian Shaw, Raymond McNeil, and Joshua Siegler that were conducted in this case.
Mr. Nix, you're not doing a very good job.
They've never given me no copies of no depositions, Your Honor.
They may not have done them. They may not have transcribed them. That's something you have to do on your own.
Yes, sir. Well,
I mean, you have to have them done. So I don't know. I mean, that's something that you're going to have to do yourself. I can't help you do that. Once again, do you wish to have an attorney appointed to represent you?
sir,
Do you wish to have an attorney
I
appointed?
do not know, I do not want Lord McCarthy. No, sir.
You're fixing to litigate yourself to a mess.
No, I just have to do it myself. Here's yours, your copies,
I
Your
don't
Honor.
need a copy. You can
This is for the motions I'm filing.
file them with the clerk's office. I don't take them. All right, we'll see you January 19th at 9 o'clock. We'll leave you on the February trial document. We'll use that 19th as a motion day as well as a pre-trial day. Trial management.
Yes, sir.
Your Honor, I understand that this is an allegation, both contain allegations of protection order violations. Through reading of the probable cause as stated before the court, the allegations are nonviolent in nature. Taking that into consideration, along with the fact that Ms. Serrano at this time was dealing with homelessness, she now has a place to stay with family in Lakewood who will take her in that is separated from the protected party in this situation. She has a plan where she can execute and not be in any contact with the protected party. In light of that and the fact that she now has a place to go, she will not be a flight risk. She will not be a community safety concern. And for those reasons, I would ask the court to consider releasing her today and not impose bail. And if the court is inclined to impose bail, then the least restrictive amount possible.
Okay, thank you. Ms. Serrano, I find it so frustrating when people violate court orders. It's always given to you in a manner that is crystal clear. It is stated emphatically that you are to have absolutely no contact with Nicholas Cougar Harrington. You and Mr. Harrington are obviously both aware of this, given the fact that Mr. Harrington did not want to give his name at the time of these alleged incidents, very likely because he knows the order's in place and that's going to be problematic. The fact that it has been repetitive, and when I look at your history, it's been repetitive for ages and ages and ages, that you disregard court orders, and that frustrates me. The fact that you now have a place to stay is the reason that I am going to release you on your promise to appear.
Thank you.
I am going to release you under the condition that you follow these orders. And I am going to indicate for the record that if there is any allegation of a violation of an order for protection, that you will be held on no less than $10,000 cash or bond for each case that we have you for here in Lakewood.
Yes, ma'am.
I'm not playing games with this. When there is a court order in place, it is my expectation that you will follow it to the letter. Is that clear?
Yes, ma'am.
What will happen if you are found with Mr. Harrington?
I will be brought into court again and I'll have a $10,000 bail
On each one of these cases.
on each case.
So please take this as seriously as I do. Please value yourself and value your integrity.
Yes, ma'am.
Value your freedom. And I would love it if you would either stop by the Pierce County Resource Center that's right across from Pierce County District Court and talk to them about some of the opportunities that are available there. There are a lot of really great resources that
Okay.
you could take advantage of.
Okay.
And that would help you help yourself as you move forward here. I just think that you deserve better than the hand you're playing yourself right now.
I agree. I agree. Thank you.
I hope you do,
I do.
because just being in and out of custody and having to deal with someone who doesn't know you and doesn't know your life and doesn't know your story, lecturing you, has got to be really irritating. Having to rely upon people who are, young enough to be your children to try and help you get through the difficulties that you spin for yourself is frustrating.
Yeah.
And it's got to be embarrassing. And I really think that you should place a higher value on yourself
Thank you.
and on your opportunities and on your future. So just one of the things that I know for sure through my own series of life choices and misadventures and mistakes is that loving someone isn't enough to make a relationship successful. And when you continuously do something that puts you in harm's way, that puts you in a position where you now have, you know, I'm looking at this right here on our docket. And Mr. Harrington is the protected party on all 4 of these cases. Hanging out with this individual is not good for you. Even if it's someone that you're crazy about and you love, or if it's someone that you're used to and somewhat reliant upon. This is not in your best interest. And so please go to the resource center and let them know that you're having a hard time breaking free of a relationship that does not serve you well. And that you need to make different choices and ask for some help with that. Okay?
Okay.
That's why the resource center is there. They are there to help you to figure out how to move beyond the situations that you are presently in.
Okay.
And I just think that you could make your life a whole lot happier if you would make different choices around this relationship. And even if this individual is like your person and the one that you wish to be with for the rest of your life, recognizing that sometimes you need time apart so that you can both grow and make different choices and clean up the mess of the past so that you can move forward in a fresh, new way makes a lot of sense.
Right.
But if you keep selling your integrity by just knowing that there's an order in place and ignoring it, you're never, ever going to improve your own situation, and you're never going to help him to improve his. And I know it's tough walking away from a relationship that you are used to, even if it's not good, or even if it's the best thing ever, is really, really difficult.
Yeah, it is.
But, you know, honoring an order, honoring a commitment and a responsibility, like following the rules of release and then showing up, will help you start building some pride and some resilience and some satisfaction in the fact that you can make good choices. You can do what's right for you. You can follow rules and do hard things and show that you can improve your life step by step every day. Okay?
Yes, ma'am.
So, I am appointing Horwath Law since they represent you on some of these other charges. We'll just make sure it's consistent.
Okay.
Your next hearing is going to be on April 11th, 2024 at 1 p.m. Your presence is required on time at the courthouse at 1 p.m.
Yes, ma'am.
Speedy trial begins today, March 8th, 2024. That means when you're out of custody, it will expire on June 6th of 2024.
Yes,
So I
ma'am.
think it's pretty clear. This is the ball. I'm handing it to you. It is in your court. Thank you. I saw you catch it. Everyone else did too. All right. So here's the thing. If you choose to violate that order, you know exactly what's going to happen.
Yes.
If he calls you, if he shows up at yours, you need to immediately message your attorney and say that Mr. Harrington just showed up here and I am, you know, in this house and I'm not leaving. If you are hanging out in a park with friends and he shows up, you must immediately leave. If you don't, you are in violation of the order. And one of the things that you can do, I mean, I'm not going to advise you what to do. That's not my role. But reaching out to your lawyer and asking for their advice in that moment. Should I call 911 and let them know that the protected party is harassing me? The protected party is following me. I am attempting to walk away and the protected party is behind me. Tell your lawyers that so that they know what to tell you. But it is in your court. You are responsible for your own situation here. And you now have a place to stay, so stay there. You know, if you walk out, that opens you up to him finding you. If you're inside, you don't have to answer the door. Okay? So please just make good choices, be safe. abide by
ma'am.
all of the previously imposed conditions on all of the other cases. And I am releasing you. But as I said, if you come back before me in particular, I will have no hesitation just saying the way I keep you away from him is by holding you in custody, because I have made crystal clear what my expectation here is. And if you can't follow a court order, then we have no recourse other than to protect you and the community by keeping you away from this person that has an order against you, okay? So I've signed off on this. I'm indicating that we're serving it on you. I'm gonna ask, let's see, that's not the right. Yeah, Ms. Mann, if you could update her address, please. So right now, I don't know if this is like the foolish optimist in me. I'm feeling good about our conversation. I'm feeling good about you. I want you to be successful. I want you to be successful so much, and I hope
Thank
you
you.
do too.
I do too.
Okay?
Yes,
All right.
thank you.
Okay, make good choices.
Thank
And I'll
you.
ask your lawyer to please sign again. I knocked your signature off, of course. Thank
Okay,
you, Ms. Mann.
Thank you.
All right, best.